Testing, testing.
Testing, testing. Testing, testing.
All right. And we're live. So, welcome back to another rendition of this week's trial uh, update on the federal case against the city for the homelessness fraud and taken on by a coalition of lawyers that have banded together, particularly from downtown, suing the city for basically the mismanagement of funds used in the Alliance settlement agreement, which initially the understanding was it was supposed to be just a simple contract dispute. You know, city did not hold good on its word for the Alliance settlement agreement, but their understanding is that one agreement really is multifaceted and connected to so many different facets. And so that's what we're going to cover today. We're going to cover the brief overview of what I believe were some of the best highlights. I'm obviously not going to be able to catch everything. I'll give some of my opinions on it with the hope that people get a more holistic view of what's going on rather than just a very finite small one facet, which is the settlement agreement. Because if you haven't figured out by now, the issue of homelessness really is connected to so many bigger acts of criminality, particularly by the part of government on colluding to launder money that was supposed to be used for legitimate purposes. In this case, the alleviation of homelessness and poverty, but instead, rather, it was used to line the pockets of developers and other special interests, all really in one way, shape, or form tying right back to developers. And so, who did we have on the stand today? Well, we had a couple of people. We had Matthew Szabo again, the Chief Administrative Officer for the city. And a couple of different questions were asked of him, but we'll go through some of what I thought were some of the highlights. So one of the things that Matthew Szabo was questioned on, was testifying to, was whether there was any sort of accommodations that the city could, in fact, reasonably accommodate as far as homelessness population as a percentage of the overall population. And it was discovered that about 60% of the unsheltered, the city per district can accommodate 60% of people to be homeless, which is quite a high number. I was honestly baffled when I saw that. I don't even know how they came to that conclusion. No clarification was brought up on how each district you could have your total population that you can accommodate to be unsheltered homeless people up to 60% of the district, but that's what was testified. Probably the most interesting bit that was testified to was whether the words reduction and removal were defined as they related to the reduction in unhoused and homeless people. There's no standards, neither in the settlement agreement, neither in any other records, that clearly define what the heck a reduction means. What the heck does removal of homeless people mean? Does that mean that they are simply in a shelter but still without a long-term access to home, but still living well below the poverty line? What does that actually mean? Can they access basic necessities? Another question that was asked of Matthew Szabo is the phrase meaningful reduction in homelessness defined. He answered no. Is substantially reduce homelessness and just overall the word substantial defined anywhere? He answered no. And that has to do with several times in the agreement they talk about, a meaningful reduction in unsheltered and unhoused and homeless people. But they never given any actual numbers as to whether that means 5% 10 years down the road overall, if that just means, you know, the people from one particular area and the people that apply through a specific program in that area. It's never defined. Um, Probably the most interesting one I thought was asked directly of Matthew Szabo was, is permanent housing more expensive than temporary housing? Well, Matthew said yes. And it was clarified by the council that they meant overall long-term permanently housing somebody is that less expensive or more expensive than housing somebody in shelters. And the repeated turnover in the revolving door that is pushing them to another shelter, pushing to another shelter, and the management services incurred as a cost to manage all that infrastructure, which in my opinion is it's just total nonsense. That's utterly ridiculous. Matthew was asked, did the city have, at the time of signing the settlement agreement, did the city in fact have the 12,900 or so beds to provide as soon as the agreement was signed and the start date on the agreement showed? He answered no. And he clarified that the goal was to provide those beds. And you got to keep in mind the phrases and the terms that come up in this whole case are very important. The differences between, like we just talked about, reduction. Last week we talked about the differences between create, the differences between, and the definition of words like removal. And those are important, right? Those are important. The differences between a bed and a unit, all of that is extremely important, not just because it's clear that in this whole settlement agreement, but even more broadly speaking, homelessness in LA City and LA County proper, these were never really objectively defined. And so it's quite easy in that situation to just pull out random numbers without any sort of basis as to how you got there and allocate all manner of percentage of your budget under the guise that you're meeting or trying to meet some sort of goal. It's not defined in any shape or form, and you can constantly move the goalpost as to what that goal actually is. And so the city had no such access to beds. There was no such definition as to when it would have access to all the beds, in what form those beds would come, and how they would measure each and every bed, and the cost for each of the units that would actually house and contain each of these beds. Of the 11,002 beds, Matthew was asked how many of those beds specifically come from funding given by LAHSA. He answered that it was less than 10%. And they asked, how do you come to the calculation of where the remaining beds to fulfill the 12,900 total value? What's the KPIs, the equation, and the basis for doing that? Matthew refused to clarify. Matthew was also asked, what happens when permanent housing is built? Are the permanent housing units now counted as part of the beds that were considered for temporary shelter, or are those counted separately? Matthew answered, yes, in fact, those are double dipped counted, which is a similar issue explained last week where I went over parking lots and how the city allegedly had these parking lots that you could sleep over, never actually provided proof of the existence of the parking lots, but also never clarified how many alleged beds they would be using per parking lot and what the shape and form of those beds would be. Does one car equal one bed? Or if you have, say, an SUV and you could sleep two people, or even a small sedan and you roll, the front two seats back, does that count as two beds? There's never clarified. So this pattern of deliberately and intentionally not putting clear definitions to very key words it's prevalent. It's ever prevalent. It's ever present, and it's a big issue. Moving on, Matthew was asked, "What does an open bed mean?" And he answered, "Any bed that is open and occupiable, and not yet occupied." And then he was asked, "What does an in-process bed mean?" He answered that it means it's any bed in any phase of construction or any phase of being, air quotes, approved. He was then challenged, what does approval mean, and approval for what and by whom? Matthew clarified that approval means approval from City Council to move funding into the program to which that bed pertains to, but is not yet connected with a specific service provider. And this is where it gets really important. All these little nitpicky details that people think are, you can just glaze over, you really can't. Because it's exactly in the details that you ultimately get wide-scale fraud, okay? That's what this is. But it's not just the act of the fraud that's the key issue here. It's something I've been repeating to people inside the courtroom that are watching, and other outside conversations I'm having. The issue isn't really the fraud itself, it's the collusion and all of the different actors that deliberately and knowingly, knowingly have come together to launder this money, mismanage it, and just completely hyperinflate and allow people to get away with it and not be criminally prosecuted. That's the ultimate issue at hand. We have a fundamental issue where you have a sitting city attorney of Los Angeles that is not, is deliberately not prosecuting developers for stealing money through complex schemes, either at the civil or criminal level. And particularly at the criminal level, you have the total mismanagement and total misuse of public dollars. Some are bonds, other are grants, and you have the outright perjurious statements made on court records and other official records, knowingly and deliberately, and those people getting away with it. That's the real fundamental problem at play. Yes, money was stolen, and yes, in this case, it's to the tune of $2 billion, but that $2 billion is actually not the real number for the fraud that we're talking about. The fraud is of absolute epic proportions. We're talking about things that are in the sum of trillions of dollars. And the reason why that's the actual number and the $2 billion is an absolute chump change compared to the real cost here is because these real estate projects and these real estate deals are not just for a year or two. In fact, they are for decades. In fact, one of the deals that Matthew signed the city up for is a 55-year long term leasing agreement. Okay? And it's not even that's really the issue. It's the guaranteed profits as a result of all of these contracts, meaning that developers are getting a 100% guarantee. Nowhere else in the sector of business, in the sector of operations, and in the sector of finance do you get an absolute guarantee, and with such high yield guarantees over such a long period of time, quarter after quarter, year over year, decade over decade. And to what extent the guarantees are. These interest rates, what is the context of the interest rates? Is it regarding a made-up equation? Is it regarding current market price? Is it regarding whatever the adjusted market price that they're predicting to be? What is that basis? That's where the real big money comes in. The delta between what you're spending right now to what's being guaranteed and what that guarantee means. And in this case, like every other case that involves the abuse and misuse of public funds, it means that public assets like buildings, when the city can no longer front the cash, it means they sell off public assets like parks and other buildings to private entities, and you lose access to all that infrastructure. You lose access to parks, you lose access to rec centers, you lose access to parking lots, you lose access to all that public infrastructure that was built and maintained and fronted by the taxpayer, but now is wholly owned by a private entity, yet is still being fronted by the taxpayer because of all the money that they used and abused as part of these fraudulent programs. And not just for a year or two, and that's something that people need to understand. Mayor Bass is not the sole person that started this homelessness fraud in the time that she was in office. It's been going on in LA for years. It's been going on all across the world, all across America for sure, for years. It really climaxed with Mayor Bass and Heidi Feltzing Soto in office because they ramped it up to the 9th degree. But that's not really the main problem here. It's not just that Bass is the perpetrator and the end-all be-all. It's not just that Heidi Feltzing Soto is the perpetrator and the end-all be-all. Yes, they do have legitimate culpability and liability by allowing real developers to do this, by knowingly in their policies not requiring the tracking of this data and defining these very key terms, whereas other programs and policies likewise across America, in fact, they do have these definitions. And yes, there is abuse, but not to this degree. And that's really the key issue that I want people to take away from this. This case is not just a siloed case. It just so happens to be that LA is so damn well known and the magnitude of the fraud is so bad, the magnitude of criminality is so bad here, that it's easy to lose sight of what the real full big picture is. We're talking about trillions of dollars at play here, and that's the real big money. That's the true money. The cost per unit, the cost really per bed to maintain in terms of service provider fees over the long run, over other utilities. That's the real issue at play here. That's the actual true story of homelessness in LA City, in LA County. It's the collusion of all of these government entities along with developers to make it happen. You can't have this complex and sophisticated racketeering ring, this entire criminal ring. You can't have that with just one mayor and one city attorney. There's all sorts of people involved, and vast majority of them are city officials that are 100% in on the fraud scheme. And that's the issue of the homelessness problem. It's that there's major fraud and there's major collusion with the government to make it happen. That's the real story. And so with that, we're going to move on to some of the other testimony that we heard today. There was 2 other people on the stand. We went very late again, as usual. They're going to start back up again tomorrow at 8 o'clock. I'll be there. Moving on to just some final testimony that Matthew Szabo was asked. So yet another term that was counted as a program or service to help house and help provide to unhoused and unsheltered homeless people is something called family reunification. Well, Matthew Szabo was asked, what does family reunification is? What is it? What does it mean? How do you count it? And he openly admitted it's not defined, it's not counted, yet it's still referred to as a bed. So again, lack of definitions, deliberately vague. Matthew Szabo was then asked, what is shared housing? He clarified that it's a unit with multiple beds inside. And in the case of the Alliance Settlement Agreement, it typically means that you're sharing utilities such as shower and restroom with others. What is shared parking? This is the program I mentioned as of last week, where allegedly there's lots around all over the city in different districts where people are lawfully allowed to live in the car, and they're provided, or allegedly supposed to be provided, But based on all the testimony that I've heard of people in the different districts and the friends that they have and some of the other records that people are sending my way, it's clear that it's not the case, that these alleged services are actually not even being provided at all, but yet are still being counted as such. Shared parking, then they asked if shared parking also counts towards the bed count, the overall maximum bed count. And Matthew Szabo, of course, confirmed in his testimony what I described last week and I'm describing today, which is yes, we in fact do count these parking lots as a bed. But how that definition works was never clarified. He never clarified if one car of any size equals a bed. He never clarified if the city's going to set up cars, if there are going to be trailers on the lot. None of that was clarified. One of the most damning next questions that was asked of Matthew Szabo was, is it policy to do community outreach first and obtain an intake of the individuals coming through the programs to understand their individual cases and individual origin story of how they came to be homeless? Is that a policy to do that outreach and intake first before providing services? He answered yes. And boy, oh boy, the reason that was so damning is because they admitted last week that they don't do any intake paperwork at all. No intake due diligence at all. Meaning they don't take any time to consider how it is that this person became homeless in the first place, both on the individual level and on the institutional level. But they admitted, the city, that they understand that there are legitimate scientific reasons and that it's predominantly institutional factors that result in the homelessness, particularly the widespread homelessness. They admitted that institutional issues are what lead to people being homeless in the first place. But yet, they have their own policies set by the mayor's office and duplicated by the chief administrative officer's office to have such a policy in place. And it counts towards the settlement agreement directly that this case pertains to. Next up, Matthew Szabo also clarified who else makes that policy. At first he was reluctant. He was very reluctant to answer this, but the council asked, who else makes up this policy? Whose policy is it? Well, it's also the heads of LAHSA. Okay? It's also the heads of LAHSA. He said there might be additional people, and he might need to there might be additional agencies that have these policies, and he would need to confer with them. He was challenged on who, not in particular individuals, but which other agencies is he referring to. He failed to answer and said, and just outright did not answer or provide any sort of clarity on which these other alleged agencies would be. Matthew Szabo was further challenged on tents and the removal of tents. We talked about people. People have talked about the street sweeping programs that Mayor Bass particularly champions, and the clearing of encampments. Okay, and he was challenged on the removal of encampments and tents and so forth. And the question posed was, what's the basis for the city to declare that encampments, tents, pop-up shelters are to be cleared and or considered hazards? Matthew Szabo said it's the determination of some alleged environmental analysts coming to that conclusion and submitting it to the city. No clarification was provided as to where these analysts come from, to which department these analysts belong to. the criteria that these alleged environmental analysts use to determine whether something is a hazard or not. He was further challenged to say that, so then are tents removed if and only if they are health hazards? He answered yes. Then he was challenged and said, so you are saying that tents, encampments, and pop-up shelters are cleared and are cleared if and only if they are deemed health hazards, as by what you say are supposed environmental analysts coming to that conclusion. He then says, well, no, that's not how it works, but then retracts it and says, well, there's environmental analysts that come to that conclusion, meaning he was trying to cover his own self by saying, well, actually, I'm not the one that makes the determination, the mayor isn't, my office isn't, there's some magical environmental analyst somewhere that give somebody, which again, as to who gets that reports by these magical analysts, that's not to be seen yet. It was never clarified. So he was trying to backtrack to this safety of, well, there's these analysts, these environmental analysts, but no clarification information was provided on who and what and where and how regarding these environmental analysts. And just before he got off the witness stand, and this guy has been going on the stand since 9 a.m., he was asked whether there is a requirement to report on the quantity and the date and whom did the clearing and sweeping of tents, encampments, pop-up shelters, and RVs. This is a really big one. I gotta tell you, man, this one even blew me away. But so I want to take a step back from that and explain. So Matthew Szabo was asked on the witness stand to clarify and state whether the city is required, as part of the settlement agreement and or otherwise, if they are required to report the why and how and who of clearing tents, encampments, pop-up shelters, and RVs. He answered no, meaning that when these street services, when these street sweepings happen, there is no policy requiring them to report the who, what, where, when, and why, and how to anybody. Not even for them to keep a record of it. Now, obviously, they do, right? They must to some extent. Whether they care to share that is a different story, but clearly that's what we're getting towards. And that's just insane when you take a step back and think about that. How is it then you can confidently say that under XYZ key metrics we're doing great, but you don't define what those metrics are? You have no way of determining how much closer you are to helping shelter people and helping eradicate poverty and reduce homelessness. When you're literally saying we don't even keep a record of this stuff. We don't even keep track of when these encampments and street sweepings actually occur and what happened at those street sweepings and by whom it happened and when it happened. Now we obviously know they obviously have some sort of records because they announce it on the street, but they fail as part of the agreements, as part of policies, and this is a Mayor Bass thing as well as a city attorney thing, who should have told the city that you need to do this. This is a major issue of liability, to be required to log that information, and they don't. It's simple, and they're not doing it. And it's because they're so brazen in their criminality and their fraud that they're just saying, screw it. Who's going to challenge us? And even if they do, what's the outcome? They're not going to send us to prison, which they should, and it needs to. And I believe, again, that's ultimately where this case is going towards, because conservatorship is not the issue, okay? The issue with this case, like I said previously, conservatorship is not the key issue. That is such an irrelevant factor and facet in this. We know that's going to happen. But the important part is the basis and how you get there. That's the important part. How do you get there? Are you going to hold the people that were colluding to make all this fraud happen accountable criminally? Are you going to prosecute them? That's the real discussion and issue at play. And for those that say this case has been dragging on for so long, you got to understand how this stuff actually works. Judge Carter is not a god. He is simply a judge. And as such, he only has the authorities of a judge. Judge Carter understands that the law firm representing the city are a bunch of utter disgusting a-holes. And he knows they're going to appeal. And he knows there's going to be further proceedings. And he knows they're going to literally object to every friggin' question. Just cause. So he's doing everything procedurally as perfect as possible, so that his decision doesn't get overturned, and more importantly, the conditions with his decision do not get overturned. That's the important part. And for him to have an opinion based on upheld decisions of his that count that much more, so that it incentivizes federal agencies to prosecute the Heidi Feldstein Sotos, the Mayor Karen Basses, and all her deputies of the world. Because LA is not unique in this. So that's the real act. That's the real pathway forward that Judge Carter is setting and understands. He can't help that the case, or excuse me, that the lawyers to the city and the city officials doing what they're doing, he can't help that. That's not his authority. It's not his wheelhouse. And you got to understand, this is the long game. He understands that this is just what's going to happen. All he can do is his job as a judge. That's all that he can do. He can't bring forward cases. He can't litigate cases. He can only judge a case that's before him. And that's exactly what he's doing, and damn well at that too. And so with that, we now have Matthew Szabo off the stand, and we're shifting to the second witness for testimony today. And that second person is Mr. Brian Ulf. That's ULF, Brian, the common spelling. And he's the CEO of an organization called SHARE, which stands for Self-Help and Recovery. And they specifically are a nonprofit that offer referrals to people who want access to social support groups like Alcoholics Anonymous, AA. He testified on his personal story of how he came to be in that position, and Brian explained that he actually started the nonprofit directly through lived experience of his struggle with substance abuse, and he actually had a grand mal seizure about 30 years ago. The nonprofit has been around for about 33 years, and the interesting thing about this particular nonprofit, to which I have no affiliation of, I'm just covering the testimony that was discussed. The particular interesting thing about this nonprofit is that the people on the board have direct lived experience, and the cost that they're able to provide actual shelter is an absolute fraction of what everybody else has testified to, including a woman last week who was the CEO of another nonprofit and had worked with Yahoo and a bunch of other tech companies to do some of this initiative, homelessness eradication initiatives, but she did it for Northern California. So Brian was testifying to the cost that his nonprofit is able to do some of this work, and the history that he had with pleading with the city to help them do it at a fraction of the cost and truly help people out. And so he was explaining at first what they do. And so the way their nonprofit works is they provide private rooms to people where a bed is a unit, and each of those rooms has their own amenities, from internet, from restrooms, but not only that, each of those units are fully furnished. So you have a kitchen, you have a bed, you'll have a sofa, all that is provided in the unit. And they don't just provide the housing aspect, they also provide directly in-house mental health services, where they have the actual social support groups like AA actually hold their meetings inside the same facility that the units are located in, so that people do not have to travel. And more particularly, uh, that they're not exclusive just to sober living individuals. It's not a sober living facility, but they help people get to sober living, and they provide such services. So he was the starting line of questioning was asked of Brian as to what sort of contracts he has with the city. He was explaining how he had a contract with CD3 and some B-chip funding from the government, for the governor, excuse me. And he was asked about how much is rent at each of the units approximately. And he explained that each unit is roughly $600 to $900 a month. They get about $3 million in the B-chip funding from the governor. They have some contracts with the county that range about $2 million. And about 2 years ago, a proposal was made by Brian and his nonprofit for the city to front $8 million in order for them to house 2,000 people for an entire year, where each room would be all inclusive, or excuse me, $2 million for 2,000 people, where each unit would be all inclusive, meaning the 2 million, or excuse me, the 8 million is the full cost. So 8 million for the full cost of everything for 2,000 people to house them for one full year. So that 8 million includes the management services, it includes the rent to the landlord, it includes all the utilities, it includes the maintenance and upkeep. $8 million for 2,000 people for an entire year, all inclusive, including the social services that were to be provided on scene. The only thing they do not provide, which is particular about his program, is they do not provide food. So that number, when you start breaking it down, right, when you start getting into the calculations of a day rate, the cost of a bed, the cost of a unit, this is where the breakdown starts, and you start to get an understanding of how much this all really costs. Brian's calculations here and what he was able to do are absolutely just peanuts in comparison to scale. What it costs him to do it and provide competent services at that is astronomical. In Brian's model of doing business, of the people that go through the program, and let me back up for a second. The city ultimately denied his proposition for $8 million to house 2,000 people for an entire year, all inclusive. That was denied. That proposition was denied. Brian made it happen through outside grants and philanthropy, and they met exactly that cost. $8 million to house 2,000 people in separate units with their own beds, in private rooms with their own access to facilities. So no shared bathrooms, none of that. Private rooms, $8 million, all inclusive, management fees included. And the shelter and the actual units themselves were also fully furnished. He was able to do that, as well as mental health services included. And Brian explained, and he was asked to clarify just how that can be and what the success rates for people post that program did, meaning Did any of those 2,000 people go into homelessness afterwards? Or what happened to them? Did they remain sheltered and housed afterwards? So get this. In Brian's model of not only the housing part, but the social support services afterwards, uh, 96% of all participants remained housed thereafter. 96%. 96% remained housed. Compare and contrast that to the programs by the city. Inside Safe, I reported last week, 53% exit straight to homelessness afterwards. The Roadmap program, 73% exit straight back to homelessness. The Alliance program, about 62% exit straight back to homelessness. Whereas 4% exit to homelessness, and most importantly, the 96% remained housed. So the key takeaway here is, again, the devil is in the details. The devil is in the details. The percentages I shouted off with the Roadmap, Alliance, and Inside Safe program, those 73% of people being homeless, that does not mean that the rest of the people become housed. No, it literally means, in the case of the city, those people that are not part of that 73%, they're just gone. They're not tracked as to what the hell happens to them. They're totally disregarded and discarded and utterly forgotten. Nobody knows what the hell happened to them. They literally don't know. But they do know 73% of them absolutely go straight back to homelessness. So you have a worse shot of going through these programs to help you be sheltered and housed than you do making it on your own. And you get zero services for treating symptoms of root issues like substance abuse addiction to get stable enough to have long-term success. But that's not the case with what Brian has seen in the 33 years that they've operated Share. I mean, that's just insane. Like, I don't know what else to call it. That's utterly insane. His testimony, understandably so, lasted only about 30 minutes because the city was really ready to get him off that witness stand because, damn, it was some great testimony. He gets off the witness stand, and the last person to get called today is Lisa Ragas. She was the then director of the Skid Row Trust Fund. And the thing with Lisa is she actually came out a while back while she was tenured to oversee the fund, where she ultimately was a whistleblower to say there's major corruption happening here. The city is doing a poor job. The service providers are doing a poor job. There's money laundering happening and fraud happening left and right. And when she was questioned by the city, rather than asking her legitimate questions as to what happened during her tenure, they just immediately started going after her as character assaults. Okay? And some of the records were shown what was happening with the Skid Row Trust in regard to cost per unit, and you're gonna just freak out when I read some of these values compared to the values I just explained earlier with Brian Ulf's program over at Share and their cost per unit. So the cost per unit shown that happened under the Skid Row Trust were as follows. The usual price per unit under the Skid Row Trust was about $1 million. So $1 million for one unit. $1 million. There was no definition as to how many people that one unit could house, but it was definitely not to the scale that Brian could. $1 million, though, is what you can expect. The rest were essentially questions that, like I explained, had no relevance whatsoever. There were stupid questions asking her about whether she worked for the city, which she obviously didn't, whether she had ever worked for the city, which she obviously had never, whether she intended to work for the city, all this completely irrelevant and speculative crap to make it seem like, well, because you didn't work for the city, therefore you can't speak at all to what the city did. You can't have an opinion on what the city did or didn't do. You can't make any sort of competent, independent opinions and analysis and judgments on what the city what's a good practice for the city or overall good practices, and whether the city doing it in this way constitutes a good or bad practice. And that line of questioning was ultimately shut down, thanks primarily to the clock, and it was clear that the city had nothing. I mean, we saw Mr. William Shakespeare, I'll call him for now. I mean, this guy is an utter clown. The lead lawyer for the Gibson Dunning whatever firm, I forget the third name in the third part of the name of the law firm that's representing the city. This guy he just doesn't get it. He thinks it's a theater of, he thinks it's supposed to be some artistic display. Judge Carter doesn't care for any of that theatrics. He's going on and on about, reminiscing and, pontificating on the meaning of a word and how interesting words can be sometimes, and just this utterly bogus and trash nonsense that has nothing to do with the facts of the case. That has nothing to do with the outright criminal behavior of the people in the city and the long-standing pattern of behavior by the government on this very issue of fraudulently laundering and misusing public funds geared for eradicating homelessness and poverty. And they look even worse because this guy, as well as his fellow lawyer deputies, they object to literally everything, and they just don't get it. They literally don't get that it makes them look so bad. Objections are supposed to be for critical, the most important tidbits, not just object to everything just cause. And the objection grounds are utterly stupid too. And they keep doing it. And they keep doing it. And of course, Judge Carter is going to allow them to do it because they're going to eat their own words. And you can't stop your enemy. You should never do so when the enemy is destroying their own case. So of course Judge Carter is going to allow it, but it looks hilarious to see in person. And they do it over and over again and over and over again, literally every day. Most of the time is spent going back and forth on the stupid objections that the city makes, the lawyers for the city make. And because the objections are so stupid and vague and just utterly ridiculous, most of the time is spent on Carter saying, clarify that, is this what you mean? And then they clarify, and then Carter says, nah, this is stupid. I knew it would be, but I just gave you the chance to clarify, so you couldn't say that I never, gave you the chance to clarify. Overruled. Let's move on. That's like 90%. 90% of the entire time spent during the trial. That's exactly what it is. Stupid grandstanding. But Carter does a good job overall of limiting it and moving things along, because he knows the city is trying to run out their time with him, and he won't have any of it, and that's why he's not allowing any delays. The best part, I almost forgot this, the absolute best part was when the lead lawyer guy from Gibson Dunning, whatever, he was trying to, it was when Brian Ulf had taken the stand and he was testifying about the absolute true low cost to be able to do this, even in a place like LA, to shelter and house people over the long term. While Brian was explaining all the numbers, the 8 million to 2,000 person for the full year, no extra cost, all included. When he was explaining that, literally as he was wrapping that sentence up, this dude from the city side, the tall guy, and I know his name's like Khan or something like that. I had it last week. You can replay it. Honestly, his name is irrelevant at this point. That's what I'll call him, because this guy, he's a clown. He's an irrelevant clown, and he gets up and outright lies to the judge over the dumbest thing he could possibly lie about. He says, "Your Honor, I have to take a phone call right now. It's an urgent phone call, and therefore I need time to break right now." And the judge outright stops him on his tracks and says, "How long do you need? And we can still proceed without you here. You can go and take the call outside. We still have the session here. Your fellow coworkers and co-counsels are here, so we don't need you to be present in order for the proceeding to move forward." And this dude just shut his mouth and sat his ass right back down. And I was scratching my head. I was thinking to myself, well, wasn't that supposed to be a really urgent and super important phone call you needed to make just a moment ago? But now it doesn't matter at all. Now all of a sudden it's totally not urgent and important. Now it can wait all of a sudden. I mean, come on. Wow. The sheer level of incompetence, arrogance, and outright stupidity by the side of the city is truly baffling. You got to see it in person. I'm glad that I'm at least reporting on it so that you guys have an understanding, because the transcripts do not do it justice. You got to see the faces of these people as these councils for the side of the city are, just squirming in their seats because they know they're SOL. They know. And they're throwing their clients under the bus. They're not helping address real issues at all. And it's just a clown show, really. It's for the city anyway, for the city. So with that, I'll see if there's any comments or questions. And if not, we'll wrap up. And we'll report back tomorrow. Let's see. All right, seeing none there. All right, well, with that, we'll wrap it up here, call it a night, and appreciate you guys. We'll see you in the next one. Peace out.